But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you. State your appearance, please.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under.
In today's courtroom session, tensions rise as the judge confronts confusion over who truly owns and occupies a $1 million property in Ann Arbor, Michigan. The case involves layers of bankruptcy filings, alleged fraud, and a property that's been stuck in legal limbo. Watch closely as attorneys, occupants, and the judge navigate through complex bankruptcy law, property rights, and the thin line between rightful ownership and legal obstruction.
Any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal.
What we're hearing here is a critical piece of the case. The plaintiff's attorney is introducing evidence that the bankruptcy court found this property filing part of a scheme to delay, hinder, and defraud the creditor. That's serious language. It suggests a pattern of legal manipulation, using multiple bankruptcies to block foreclosure or eviction. This is why the plaintiff is now asking to reopen the case and proceed with eviction. Since the bankruptcy stay, the legal freeze on action has already been lifted.
Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay. And that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it.
Notice how the attorney lists a series of bankruptcy filings tied to this single property, each under different names. This pattern is often called serial bankruptcy abuse, a tactic sometimes used to stall evictions or foreclosures. The attorney's argument is that this is not coincidence, but a deliberate attempt to keep the property out of lawful possession. By requesting an immediate eviction or financial bond, the plaintiff is signaling that patience has run out, and they want the court to act swiftly.
Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
Here's where the emotional tension spikes. Ms. Banks, visibly nervous, asserts that she's appearing only to protect federally vested occupancy rights, but refuses to consent to the court's jurisdiction. Legally, that's a contradiction. If you don't recognize the court's authority, you can't argue your case within it. The judge immediately catches that and instructs her to sit down, reinforcing the principle that jurisdiction is the foundation of all courtroom proceedings.
The reason that I mention all of this, Your Honor,
Yeah, go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself.
The judge's explanation here is crucial. She's clarifying that Ms. Banks has no legal standing in this eviction because she isn't in privity of contract, meaning she has no direct legal relationship with the plaintiff. Her lease, if valid, would be with Ms. Whitlow, not the property owner. This distinction underpins landlord-tenant law. You can only defend against the party you're contractually bound to, not a third party who now owns the property.
The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
All right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous.
The judge now issues her ruling, reopening the case and granting possession to the plaintiff, with a 10-day window before eviction. However, she adds a significant detail: an appeal bond of $15,000 per month, far higher than the $10,000 requested. This bond ensures that if the case is appealed, the appellant must maintain financial responsibility equal to the property's value. Essentially, it prevents further legal delay tactics by attaching real financial weight to any future appeals.
Quite nervous. But I, Doshia Banks, is respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you are
rights.
not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow, who
you
is
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part uh, that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why on those,
In summary, the court sided with the property owner, affirming their right to possession and imposing a high appeal bond to deter further misuse of bankruptcy protections. The case highlights how courts balance due process with preventing legal loopholes from being exploited. It's a reminder that while bankruptcy offers protection, it cannot be used as a shield for fraud or delay. If you found this case as intriguing as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more in-depth courtroom analyses and real legal breakdowns.
grounds why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false.
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, man.
We've actually been.
I don't know that.
Okay, I know you don't know that 'cause it's not before you.
Correct.
I see, I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know I have documents that are not, that they filed with this court that are not signed. So I don't have to